Well, that was exciting. Okay, so now I'd like to invite Charles Mudd to come up for our main presentation. Charles is the founder and principal of Mudd Law Offices. He has developed a broad-based practice of representing local, national, and international clientele, and he's become internationally known on issues of technology, intellectual property, and the internet. And most recently, Charles has been developing a practice based on space law. So Charles is our resident space law expert. Charles.
Thank you. Thank you, Dave and NewSpace Chicago, for having me here again to speak about space law. And on this, and I guess I should also, just for the record, thank my youngest son, Alex, for allowing me to be here because it's his birthday. And because I missed last month, I'm here and we'll celebrate over the weekend. But in any case, great. So what I wanted to do in this program is take the perspective of if I had had a conversation or spoke to a startup that came to me with a particular focus in relation to the space industry, what are some of the things that I would end up talking to that individual about, or that company? So for this purpose, we're using Outermind LLC, and we're going to talk about the business purpose, business model that Outermind has, the incorporation status, intellectual property, and employees and investors. So when I get a call and somebody says, I need to talk to an attorney, I've got this business idea, I want to find out if it's viable or not, there's some information that I acquire or that I need to have to basically go through the process and be able to advise. One of the first things, though, is to talk about, and I'm going to get back to the business model in just a minute, but one of the first things is incorporation, just finding out whether they've been incorporated, again, intellectual property, whether they have employees and investors. But here with Outermind, one of the business model or the business purposes is space reclamation. And that is, for Outermind, essentially going out into different orbits, for example, graveyard orbits or between that and Earth, and acquiring or obtaining end-of-life satellites into light, rocket bodies, and so forth, acquiring that, pulling back the metals, and recycling them. At the same time, not only there's a profit component for that, but it's a public policy perspective as well. So I'll kind of get into talking about space debris and remediation of that. Because as you may have read or know, to really address the space debris issue, it's no longer a matter of mitigating, which we still need. We need any company that's developing satellites to have measures that their satellites at end of life will deorbit and burn up or resolve itself. But we're in a situation where we actually need to reduce the amount of objects in space in any case. The other aspect of Outermind, hence the mind part of the name, is space mining. And that would be to extract valuable resources such as minerals from celestial objects, whether that be the moon or asteroids. But returning back to whether or not the company is incorporated, it's a key aspect that I want to know. I want to know, one, before I even have an engagement letter, I need to know whether the individual is signing the engagement letter or whether the entity is signing the engagement letter. And where there is an entity or startup, typically I have both the individual and, or the one individual sign on behalf of both the entity and him or herself individually. And just to talk briefly in terms of determining the business structure, one is talking about the form, the various forms in Illinois that might exist, but on the other side of the screen you also see a location, and there are two aspects of the location, right? One is, where is the best place to be a startup, or where is the best place to be a space startup? Chicago is among one of the cities listed in 2019 for a great place to be a startup. But then you also need to be aware of what is the best state to create your business from a legal perspective and from an investor perspective, because a lot of investors may want a Delaware Incorporated, Delaware LLC, whatever the case may be. So those are kind of the considerations to go into. Oftentimes, though, when somebody comes to me, such as Outermind, they may already have created their LLC or created the entity, and so this is kind of, to some extent, irrelevant to a certain extent when the entity is already created, but it might shift in as a factor depending on what their business practices are or what they want to do beyond that. The key factor, though, is in any incorporation or limited liability company, one of the biggest aspects for those that talk to me that have not yet incorporated or created an entity is liability protection. And it's not so much to allow an individual to get away with something, because piercing the corporate veil still exists, and it exists and can be applied to LLCs or other business entities. But for straightforward business activity, the entity protects the individual owners, shareholders, and members from personal liability for legitimate mishaps that might occur in operating the business. And as kind of was hinted at earlier in a conversation I had with somebody, Outermind's particular activity that it has in mind it is ripe with opportunity for disaster or potential liability issues. So then we would go to intellectual property. One of the second things that I talk about with a company that calls me that's starting up is what have you done to protect the intellectual property? Have you protected the name? Do they even know what's different intellectual properties are? So many prospects actually call our firm and say, I want to patent my name. And have a misunderstanding of the core aspects of intellectual property, but that's why I have a job. So there are three here. Copyrights, trademarks, and patents make up 3 of the 4 main components of intellectual property. I know some of you, particularly Jeffrey, Liz in front, I'm preaching to the choir on this, but essentially, copyrights are for creative works. The example that I typically give for somebody is the John Lovitz character when he was on Saturday Night Live playing Picasso and scribbled on a napkin. We have a copyright today, under today's copyright law, you have a copyright in anything that you create. It doesn't protect an idea, but as long as it's manifested in something, whether it's electronic or otherwise, you have a copyright. But to have the protection to be able to enforce the copyright, you need to register it. Outermind really does not have an issue right now with copyright, so it's really not applicable. More applicable, though, would be, let's say, the trademark, protecting the name, protecting the brand name, logo, and then patents, and obviously that is not Outermind's technology. That's Canada R2, which actually just pulled in one of SpaceX's objects to the ISS. But we also have trade secrets, and trade secrets, and this ties into talking about employees and investors. Trade secrets are the non-public aspect of intellectual property. So there are ways that you can file things with, let's say, the Copyright Office, or the you can file certain things under seal in certain rare circumstances, but for general purposes, copyright, trademark, and your patents are all public. You're filing them with the government, they're accessible to anyone. You obviously want your trademark to be accessible in the search database so that others can see that the name's already been taken and not use it. Whereas trade secrets are secret. And a lot of times, a client of mine is being sued by an entity for a trade secret violation because it's alleged that my client went onto a website and copied coupon codes, and the company that's suing my client is claiming that the coupon codes that it published on its website happen to be trade secrets. Those are not trade secrets. They've publicly disclosed them, and they lose any kind of public or trade secret status. With trademarks, very briefly, one, you have to have it in use in commerce, or that's one aspect question that I ask is whether or not they're using them, or if they haven't used them, because there's two different ways to approach that, and then also doing the registration. A common law trademark is just using the mark in commerce. You haven't registered it, but you do have some rights with that. And then the other aspect is filing with the Patent and Trademark Office. Mud Law is my firm's trademark, and arguably it was a descriptive term, but because I've been using it for more than 5 years, it's acquired distinctiveness, and I was able to obtain the mark. Outer Mind just applied for its mark, and so Outer Mind applied for the mark in two different classes that are related to the two different aspects of its business model. One is for mining extraction of minerals from celestial objects. You see the red part is the part that a lot of the categories, when you file a trademark, the categories allow you to insert additional information that fits. So that is targeted for Outer Mind's particular business model, and then recycling of space debris, satellites, rocket bodies, and other space remnants. Trademark tips: search, obtain, watch news. You need to search before the company acquires a mark or starts using and spending a lot of time and money and investment. You want to search various databases to make sure that nobody's using it. And then obtain it, and not just obtain the trademark, but lock up the social media accounts. Our firm does reputation management as well for individuals and companies, and we have like a list of the top 60 social media sites, and I say top very broadly. I mean, then I have them segmented into what's more important, not, but we use that same list for a company that comes to us and says, I want to protect my brand name, logo, what have you, or we end up acquiring or going through that and obtaining all of the social media accounts and other relevant platforms. Then you need to watch to make sure that nobody else is using your mark, and you actually need to use it. Let's turn back to the business model, because this may be the more interesting aspects of the conversation. I certainly love trademark law, I love copyright law, but I really love right now space law. And these two particular business models bring up two different things. So space reclamation, you probably can't see all of the dots on that, but if you go to the website stuffin, stuffin.space, you can see a dynamical model of a number of objects that are registered as being in space, rocket bodies, satellites, and so forth. And in fact, you can click on any of the particular dots and find out what it is and see its particular orbit. So with respect to space, and you probably can't read it here, but the legend has satellite, rocket body, or debris. There is a report, and I meant to have it up here, but there was a report recently that going back to the difference between space debris, mitigation or remediation, there's so many objects in space right now that even if there were no other objects put into space, eventually it would end up increasing the amount of objects just because the objects would be colliding with one another. And we saw, you can also go to, I think it's Affiliated Graphics, AGI's website, and they will show you, they have an analysis of the Indian test rocket that went up and collided with one of its satellites and the resulting debris spread. And they've calculated out that even though India said there's not an issue, the debris is going to be fine, the actual debris spread will far exceed and could actually get into the area where the ISS is and pose a risk for it. So there's a lot of stuff out there. And so with Outer Mind's objective to get into space reclamation It's going out and trying to acquire the larger body objects to not only from a public policy perspective help to remediate space debris, but then acquire those objects to use and to sell. And there's even more objects in the graveyard orbit, which is about 22,400 miles above Earth. A lot of people say, yeah, let's send the satellites up to the graveyard orbit when they're at end of life and they're out of the way, but that does not mean that they're out of the risk space. So two issues with space reclamation that come into play. One is ownership on who owns the objects that outer mind will be acquired. And the other is recovery. I'm not going to get into, you had the pitches earlier, I'm not taking any questions onto technical feasibility because I'm not outer mind. Although, I mean, I created it for purposes of this exercise, but I'm not going to address questions on the technical feasibility. But the ownership, I definitely can talk about. And the most analogous aspect to this is going back to maritime law. And when you have shipwrecks or that, you know, ships that have been abandoned out there, it's exactly what we're talking about when we have rocket bodies or end-of-life satellites or other space debris. So the law of salvage provides essentially that a person who helps recover a ship or recovers objects or supplies and so forth on the ship should be rewarded for that particular effort. And that would be the law of salvage, voluntarily assist a ship to recover cargo from impending or actual peril or loss. Now, the distinction, I couldn't find a good photo, and I'd already used two ships, so I was like, I'm just going to leave the feet. The law of abandonment comes into play in that and there are a number of cases out there where there will be a shipwreck. And in fact, I was having a conversation in Florida with somebody. We were out celebrating my dad's 80th birthday, and there was a ship that was wrecked, like a yacht. You could tell it was not functional. And I was like, what is that doing over there? And somebody said that it had been there for years, and nobody had been using it and so forth. And then one day somebody tried to go and start acquiring some of the supplies, and the owner of the ship said, wait a second, that's my ship. So even though years had passed, that was still the individual ship. He still owned it. And that applies basically to anything in the seas and the waters. Now, countries have agreed to, in the modern era, they have agreed to principles that, you have the territorial boundaries within the waters, and then anything that within those waters, any ships belong to the country that have been shipwrecked over time. But you get further beyond those territorial aspects, then it becomes a little bit muddier. But the law of abandonment is relinquishment of property rights, and that does not mean, in the case the example that I gave you of the Florida yacht that somebody just left ground and not used, that's not abandoned. There needs to be a formal aspect of abandonment under maritime law of abandonment. So applying that to space law, just because a rocket body is floating, or not floating, mixing analogies, orbiting around Earth, and nobody's used it for 50 years, 40 years, however long, does not mean that it's abandoned unless the country, the state, or the company now, more recently, indicates that they've abandoned the particular property. I'll get into the law of fines. This comes up a little bit more with the other aspects of Outer Mind's business model, and that is mining asteroids, because when we get into talking about who owns or who can own the minerals extracted from celestial objects. But with respect to space reclamation, there are a lot of objects out there. If the technology exists, Outermind has a great potential to go out and clean up the orbits. However, Outermind, being a new entity, does not own any of those objects. And so if it goes out and it acquires objects that it doesn't own, it could run into some issues. Likewise, if in Outermind's activities it accidentally damages the satellite or damages an object, or in an effort to reclaim it or pull it in, and is not able to grab onto it and knocks it out of its current orbit, and that object later hits another object, Outermind's going to have some liability issues. Now, in turning to liability aspects, I want to take a step back to international law and space. Do you know how many, does anyone know how many space treaties there are? With one hand, 5. There are 5 space treaties internationally. And the first one was how many years ago? Around 50 years ago. Yeah, and then when was the most recent one? When did it actually, you know, how long ago it's been since the last treaty became a treaty? It's been about 40 years since there's been a United Nations treaty relating to space. And that last treaty is the Moon Treaty, which I'll get to in just a moment. The United States is not a party to that. The Soviet Union at the time, which had kind of promoted the Moon Agreement, is not, Russia's not a party to it. In fact, I think less than 20 countries have either signed on or ratified to the Moon Agreement. But one of the other 4, and it's the Outer Space Treaty was the first, and then there was the liability, and then there was the astronaut agreement, which is basically that we agree if an astronaut crashes in our country and they're from Russia, putting aside all political differences, the United States has an obligation to help that astronaut and to return Russia's spacecraft to Russia. And it would reciprocate, obviously, for any members or any countries that had signed on to the treaty. Likewise, there's an obligation if an astronaut is in danger out in space and we happen to be nearby, we have an obligation to help out. How many of you have seen the movie Salvage 7? One person, all right. It's one of the best space movies I've ever seen. It's Russian, and I came to know about it 2 years ago. Dave mentioned that, you know, over the last few years I've become interested in kind of building my practice into space law. I had no plans to do that. In fact, I started taking a graduate astrophysics class and at the University of Chicago to do something other than law, to just do something fun. Now, the classmates that I had were astounded and perplexed that I was taking the class for fun, but I was. As it happens, though, a number of things have combined, and that veered back and somehow came back into my practice, so now I'm doing space law. But the professor that I had for that Galaxies class, meeting him for lunch just about a month or 2 months ago, mentioned Salvage 7, and I saw it, and it's amazing. And it's kind of like the Soviet Union version of Apollo 13 and how they had to rescue astronauts. And there's a part, the reason I mentioned it, there's a part there where the space shuttle was nearby, and it relates to the Soviet Union space station that it had, that had an issue. And the Soviet Union thought that we had created the space shuttle to capture its space station because the body, the cavity of the space shuttle fit almost perfectly the Soviet space station. As it happens, well, I don't want to give it away even though it's a fact. You should watch Salvage 7. It is in subtitles though. So that's the astronaut treaty, and then the next one is the Convention Liability Convention, and the fourth is the Registration Convention, which I'm not going to get into. But the Liability Convention, of those 4 or 5 United Nations space treaties, provides a mechanism, a very formal mechanism, such that if any particular states, and when I say state here, I mean government, foreign government, or country, if any particular state it sends up an object, whether that be a satellite, rocket, what have you, and it collides or causes damage to any other object in space, or it causes damage to anybody on the ground in another country, this sets up the liability convention. This sets up how to handle those liability issues. And basically, you know, it's many times like any contract would be here if there's a potential breach, where it has, you know, you guys got to try to talk it out, work it out, and see if you can address all the issues. And then if that doesn't work, it sets up a panel, an arbitration panel. So that controls the liability, but it really doesn't address liability for companies as much as the states. But you see here, Article 2, a launching state shall be absolutely liable to pay compensation for damage caused by its space object on the surface of the Earth or to aircraft in flight. It's a very in-depth convention, actually, on liability. However, while the international treaty arguably doesn't apply necessarily to companies or citizens of a particular state, in the United States, under its Title 51 is basically our space laws and the United States space laws. Title, it's 51 USC, United States Code, Section 10101, etc. This particular section, this is the space statutes and all the related provisions. But one of them, 50914, provides that if a company obtains a license for launch or re-entry of a particular object, it has to have liability coverage to address the risks of its particular endeavors. So there is a statutory provision here in the United States that if a license that the company obtains falls under the statute, it needs to have liability coverage. And a lot. You know, for more than $500 million, that's a huge policy. And it continues on. So those are some general concepts that, you know, talking to Outer Mind, I'd be like, okay, you know, I appreciate the business model, I appreciate the aspects, but you've got to be aware that you can't just go up and collect a Russian rocket body and not face any kind of issues. You can't just go up and collect a satellite from China that may not be working or some other company. You actually have to address the ownership issues, and then you should have liability protection in case your technology affects those objects or causes damage or knocks them into an orbit that causes damage. Turning to space mining, Outer Mind identifies celestial objects that contain rich mineral resources and mines them for sale to third parties. So here again, we have an ownership issue and we have a possession issue. Because as we'll see, under the law of fines, possession is 9/10 of the law. Space mining really, again, plays into international law, but the closest analogy, although there are statutes and treaties addressing this, and I'll get into it, there's also the international maritime aspect to it, and the law of fines. We talked earlier about salvage, abandonment. The law of fines is most applicable to asteroids because abandonment and salvage, you're talking about something that was owned at one time or another by somebody. With the law of fines, you're talking about items that were never owned by anybody. And the classic example that I use is Moby Dick. And in the end, I think Moby Dick owned Ahab more than Ahab owned Moby Dick. But the Outer Space Treaty, so looking to international law, though, beyond common law, which is your law of fines, law of abandonment that's been developed by the courts over centuries, the Outer Space Treaty, that first treaty, says that nobody can own the moon or a celestial object. Fine. Some people have interpreted that to mean that you cannot own any part of the moon or a celestial object. And we can just talk about celestial object, which does encompass the moon. So that would mean that any mining, any extracted resources, anything from the moon, Mars, asteroids, what have you, cannot be owned privately or by any state either. The Moon Agreement, so some argue that the Moon Agreement encompasses everything, every part of it, but it doesn't say that. It just talks about you can't own the moon or a celestial object. So the other group says, doesn't talk about ownership of minerals. The Moon Agreement, which the United States is not a party to, says, no, you can't. And it's very explicit. I mean, you can't get more explicit than the Moon Agreement that you cannot own, a person cannot own any part of a celestial object. And then the Space Act of 2015 in the United States says, oh yes, we can. Now, these are the three principal laws beyond common law, beyond court-made law, that are at issue. And there's a concept in statutory interpretation or legal interpretation, and that if a word is in a statute, it has a meaning, that it was intended to be there. It's just the presumption is that we don't enact statutes, we don't enact treaties, we don't enact anything with a word that doesn't have a meaning or a purpose there. And so if one paragraph has a particular word and the next paragraph does not, and it's addressing the same kind of thing, there's a reason that the second paragraph doesn't have the word that's in the first paragraph. So using that kind of analysis, that if a word is there, it has a meaning and a purpose for being there, and if a word is not there, there's a meaning to that as well. One could argue, and I think this would be the prevailing thought in the United States, one could argue that because the Outer Space Treaty did not address minerals or extracted parts of a celestial object and talked about the entire celestial object, and the United Nations, such as it was, determined the need to create the Moon Agreement, which gets very specific as to extracted parts. The fact that there's a Moon Agreement, even though we're not a party to it, but there's a treaty that talks about the specifics and the extracted parts of a celestial object, and the Outer Space Treaty does not, suggest that the Moon Agreement was needed to address something that was not in the Outer Space Treaty. And therefore, if we haven't signed on to the Moon Agreement, but we have signed on to the Outer Space Treaty, that does not restrict internationally the United States or any citizen of the United States from owning or mining extracted minerals from the asteroid. Does that make sense? Now, one aspect of the Outer Space Treaty that's very important is it's not, as we talked about before, the liability convention talking about states, meaning countries, governments. The Outer Space Treaty makes a provision of that, which is a good provision, is that every state has an obligation to ensure that its citizens, and I say that in the context of persons under its jurisdiction, whether that's a natural person or an artificial like a company, abides by the treaty. So if we sign on to the Outer Space Treaty, which we did, the United States has an obligation to make every person, artificial or natural, abide by the treaty. And if we had signed on to the Moon Agreement, we would have been in a similar situation. But we didn't sign on to the Moon Agreement, and the Space Act says that we can mine. So this is The moon and its natural resources are the common heritage of mankind, which finds expression in the provisions of this agreement. The moon is not subject to national appropriation by any claim of sovereignty. Neither the surface nor the subsurface of the moon nor any part thereof where natural resources in place shall become the property of any state, international, intergovernmental, or non-governmental organization, national organization. I mean, you can't get much clearer than that. That's the Moon Treaty. We go to the Space Act, the provision that this is not the entire Space Act, it's just the provision. And it's the only provision relating to space mining in the Space Act, this one paragraph. A United States citizen engaged in commercial recovery of an asteroid resource or a space resource under this chapter shall be entitled to any asteroid resource or space resource obtained, including to possess, own, transport, use, and sell, obtained in accordance with applicable law, including the international obligations of the United States. Which is very interesting that it added that, right? Because right now, the argument would be that being in compliance with the international obligations of the United States would not include this. But if we ever did sign under the Moon Agreement, this would basically be moot and not applicable anymore. And in fact, not only, I know, saw at least two people from the Adler here. One of the interesting obligations for the Moon Treaty as well, we can debate the commercial aspects, but one of the interesting things was that it provides that if you were able to actually obtain something from the moon or some celestial object, not only would you not be able to own it, but you'd have to make it available to the international community for research. So that's kind of the aspects of the mining. And going back to the law of fines, a colleague of mine that teaches astrophysics up at the University of Michigan, I mean, I'm all in on the space thing. I got hooked studying galaxies. I'm a liberal arts major, both undergraduate and graduate school. I had physics in high school. But astrophysics, the galaxies class, was the most difficult class that I've ever taken, but it's also the most rewarding class. And I always joke, I'm proud to say that I got a B- in that class. I have a colleague that said, you know what a B- is in graduate school? I said, yeah, I went to graduate school in political science, but you don't understand. A liberal arts guy got a B- in an astrophysics class, graduate astrophysics class at the University of Chicago. So these kind of issues, though, I got hooked in that class, and then it led to the law side. And I'm talking to you here about the conversation that I might have with a startup, Outermind. But I also want to talk about the policy aspects of this, because there's the legal side in representing companies that might come to my firm, but then there's also the policy aspects. And the United Nations, we talked about the 5 treaties, but the United Nations has 2 organizations or 2 parts that are very heavily involved in outer space. It's UNUSA, the United Nations Office for Outer Space Activities, and then there's COPIAS, the Committee on the Peaceful Uses of Outer Space. And those bodies have been holding a lot of workshops, efforts, principles relating to space debris mitigation. And last year in September, they held the first United Nations conference on space law and policy in Moscow. This year, it's going to be in Istanbul, Turkey. And so I attended the conference in September in Moscow. And these issues, the space mining, the space debris, and a number of other issues were discussed, and they're very at the forefront of the international effort to kind of reach an agreement. I overheard some people talking about, conventions. The Space Symposium was not too long ago, which is why I wasn't here last month, because I was snowed in Colorado. There's a feeling that among some that we don't need to talk about policy now. We don't need to talk more about space policy. It'll kind of come on its own. You know, I'm not, you know, that old, I don't think, but I've been around on the internet side from the beginning, and the Facebook issues that we have today with the privacy aspects and the 5 billion or possible 5 billion penalty against Facebook, a lot of those issues are because the regulatory efforts failed and people said, you know, we don't need to regulate that. We don't need to address that now, it'll come later. Some members of Congress tried to regulate speech on the internet and failed. There's a remnant that's applicable. But from my perspective, I do believe that it is important to talk about these issues from a policy aspect, because those policy discussions end up leading to the development of sound legal principles and laws. And the fact that, you know, I mean, it is amazing that we, you know, it's been, what, about 45 years since the last steps on the moon, and we have this current NASA administration saying 2024 will be landing on the moon, and Bryson has said that it's going to be the first female boots on the ground on the moon in 2024, and then the plan is, or the goal is for 2028, sustainable presence around the moon. You know, when questioned at the Space Symposium, you know, somebody asked, well, why the moon? And even my wife has asked, why the moon? Why are we going back to the moon? MSNBC, some commentators joke about that, but the explanation is that we need to get to the moon, we need to get back so that we know what we're doing there, and that'll get us to Mars, and from that point. But the bottom line that I wanted to say is with UNUSA, Copia's talking about the space policy issues, it's a kind of forum like this, although it's talking about the startup, the legal and business side, the policy that develops is also going to come back and apply to those businesses. And so it's important for any of us involved in the space community to be involved in whether it's international policy or down to the local level on communities and the light pollution that we have here in Chicago. I was just looking online, and they had, I forget what organization had, but they had like 5 different field views of what the night looks like if you're in a major city, if you're in the suburbs, if you're in the country, and then, you know, the last on the far right was just a clear, no lights around. I want to move there, but I don't think my wife would go for that. So anyway, I'm happy to take questions. The objective here was to kind of start more conversation and a dialogue, and the kind of conversation and dialogue that I would have with the startup like Outermine coming to me and saying, hey, I want to mine asteroids. How do I do that? I want to recycle, I want to reclaim, you know, get into space reclamation. What are the issues? And if anything, you should leave, ownership is the key aspect. The space debris still is owned by somebody out there. And so if you are talking about abandoned objects in space, you need to make sure that they are legally abandoned before you do something. As far as the mining, again, there is no ownership, and that's where the law of fines goes back, even to maritime law, and it's really fascinating kind of applying that to it. And we'll see how it plays out with the debate between the United Nations, the Moon Treaty, and the United States Code, and see what happens. So thank you. Questions?
So I actually have a question. You were talking about salvaging orbital debris or dead satellites and so forth, and the liability issues involved there, where you might knock it into an orbit that would cause damage or something. There's a whole other aspect of that which I'm very interested in, which is the concept of satellite servicing and refueling. And it seems to me, if I understand what you're saying, that there are very, very similar liability issues if you have a satellite that's going to go, or a spacecraft that's going to go service a satellite, and maybe you don't cause damage to it, but you knock it into a potentially dangerous orbit. Am I reading that correctly?
Correct. Yeah, I mean, I think that any space activity, any activity that occurs servicing a satellite, trying to pull back or obtain an end-of-life satellite, any activity that takes place in orbit that has an effect on an object can have repercussions, and that liability will come back. The liability convention that the United Nations has, I don't think, it's not as clear that the country, like the United States, has to make sure that we abide by that, or that it would be applicable. And so it is an exposure. If you're doing activities in space, what those effects could be, which is why it's important then to do due diligence. I mean, and that's not just in space, it's here as well. I mean, an airline can't prevent every mishap. You know, when we drive on the street, we can't prevent every possible accident. The most that we can do, or maybe not the most that we can do, but the best that we can do is ensure that we're engaged in due diligence and that we're taking every step that we reasonably can to make sure that we don't cause injury to others or other objects by our behavior. And those principles that are out there on Sangamon or on Chicago Avenue apply up in space as well. And I think it's an important aspect. I don't know that you need a $500 million policy, but it could be. I mean, if you knock something into orbit and that out of orbit, and that object does not burn up entirely and hits somewhere that causes significant damage, it could be a liability exposure. Well, it would be a liability exposure. Yes?
So there's a lot of objects, and I say objects, not vehicles, because they're not controlled anymore, that are a hazard to shipping up there. And so is it going to require the United Nations to come to some form of salvage agreement, or is this something that needs to be tackled between the great space powers to say, hey look, some of this stuff's hazardous, we've got to move it. If we move it, the person that moves it is taking away your liability. But of course, then we're also getting into the subject that that's a weapon as well.
That's a really good question, and I think that I'll answer it a number of ways. I think that it should be an international agreement, and there should be some understanding, particularly like if let's say Dave has a company or doing some servicing up there, and there's a company that was giving a demonstration that they can detect, and maybe it's AGI, which is why they were doing the modeling on the Indian effort to, the missile destroying the satellite, that they can actually detect for their customers whether or not another object is likely to intersect with their customer's satellite. So they could call up and say, your satellite XYZ is actually on a course to be colliding with another object. You need to do something. If they have the power to do that, or they call somebody up. And there's not a lot of time to do that. It's more time than I originally thought, but I did the math, and you have about half a day, assuming that it was a direct line. But anyway, I won't get into that. So I think that the answer to your question is, I think that there should be some international agreement whereby if a company is up there and doing something to try to mitigate the potential damage that an object could cause, that they should have, maybe there should be some Good Samaritan protection in that case. On the other hand, if they're negligent in what they're doing, then perhaps that protection should not exist. But I think it should come from an international community, but I don't know, I don't know how quickly that's going to happen. I mean, it's been 40 years since we've had a treaty, but COPIUS and UNUSA have developed a lot of principles and doctrine on these kind of issues. They're just waiting to be implemented by the countries and so forth. Does that answer your question? Maybe?
so I have.
I think it needs to come from international, but then also contractually as well. If you're actually going up there and doing something, Jeffrey?
Hey, Charlie, you talk about not something out of orbit, changes orbit or causes damage. I wonder if there's been much analysis of the doctrine of superseding cause, because the atmosphere, for example, expands and contracts with solar radiation, and every time it does that, every orbit changes slightly. So it would seem arguably, possibly, that may have disturbed your little piece of space junk, but the Earth's atmosphere disturbed it even further before it hit something. Am I still responsible?
That's a very good question. And I think that that's kind of, I mean, it's an intervening cause. I think that it would be for a court to determine which was more at fault, whether it was the natural aspects and the shifts in the orbit, or whether it was the company doing something with the satellite that was more at fault than the other. Because I think that, I mean, and then you might have third-party liability, right? Because if the United States sends up a satellite, I mean, if the natural aspects and shifting the orbit, and that satellite ran or collided with the Russian satellite, then despite that, the U.S. satellite would probably be liable to Russia, and that would fall under the liability convention. But if it was a company servicing a satellite up there, and it was later, that's when the United States satellite collided with the Russian satellite afterwards, it would be a fact determining, just like any litigation, it would be discovery to find out and determining what was the most at-fault conduct. But it's a very good question. And that issue, as far as I know, has not actually been addressed. But I'll follow up with you on it.
It was all fine when my satellite left. It was only afterwards I had trouble.
I'm interested in kind of exploring that idea of owning the moon. If I'm up there and I'm harvesting ice or water resources, and I'm substantially changing those resources by harvesting so many of them, or if I'm up there mining minerals and I'm creating a change in the landscape, doesn't that impact the moon, and doesn't that impact the moon that everyone owns, which we agreed to and signed the original moon treaty? How does that kind of impact our desire to be able to own these resources, when maybe we are affecting the overall globally owned resource?
Yeah, and I think generally speaking, the Outer Space Treaty provides that we can't do anything that would diminish the ability of other signers to the treaty to enjoy the same benefits. So we can't destroy the moon, basically. I mean, even under the Outer Space Treaty and the ownership aspects, you get into some really interesting nuances, right? Because and another analogy might be the oil rig platforms out in the oceans, because even though the ocean beyond the territorial waters then becomes free land and nobody really owns it, you own your ship while you're out there, and if you establish something out there, you may not necessarily own the water that's underneath, but you own the physical object that's there. So translating that to the moon or the Mars, if we send landers to both or set up a moon base, we don't own the land there. Now, somebody had commented in a discussion that I had that a parallel or analogy would be going back to look at the old United States mining laws, where basically the federal government gave mining rights to companies to go and mine and extract resources on federal land. I don't think that's the best analogy, because the federal government, particularly like when we talk about ownership and everything, because the federal government didn't own the land, we took it from people that were living there. And it's an important principle. I mean, as far as we know, like even on Mars, as far as we know, there are no sentient beings. There probably, I think we know that there are no sentient beings perhaps on Mars. There might be microorganisms or something, but nobody owns that. And that's the principle of the Outer Space Treaty, is that no one on Earth can claim ownership over anything. So it's a difference, and nobody's living on the moon. It's not like Native Americans here that maybe said, we don't own the land is for everybody to take and use. The United States claimed ownership. So I don't think mining laws really are a good analogy to that. The other aspect, though, of your question raises a comment. I was giving a quick presentation over down at the University of Chicago to the Department of Astronomy and Astrophysics, and somebody asked the question whether or not, let's say we're in a place where there might be microorganisms, or we don't know, there might be some form of life. And when we talk about life, I'm not talking about humans, I'm talking about anything that could be considered alive. And a lot of people don't know that there is, even with NASA, their Department of Planetary Protection, yes, one aspect is to make sure that things obtained in space do not come back and harm us here on Earth, but it's very clearly explicit that one of the objectives is that whatever we do, we are not going to affect the possibility of life on any other celestial object. And that needs to be a core mission objective. And so the question was, what if somebody went to a place where they were extracting water? Let's say that there was a determination that they could pull water to help supply a station, and they did so, and there was a potential for life. Could they sterilize the water? Because you can't do anything that would potentially destroy life. And if you knew that that was a possibility, my answer to that question was that you could not sterilize the water. You'd have to find some other means. Now, there are exceptions to the rule and everything, and then I asked the question, how many have seen the National Geographic series Mars? Because a lot of these issues play out in the second season of that, between the company doing mining on Mars and the research that's there. And then in the audience, somebody raised their hand and said, well, I was actually in the series, and I joked that, well, it was half serious, half joking, that should have been my question, is how many of you had actually been in the National Geographic series? But I highly recommend it if you haven't seen it. So Soyuz 7 and Mars. Any other questions?
So it seems like the UN treaties are kind of based on this Cold War ethic kind of thought process, where sort of like how Antarctica is maybe set up, where it's like, let's just make a safe space for no conflict and say, but the reality of, I think, space, commercial space now, is sort of more like the Space Act, trying to encourage, so it's a whole different philosophy, right? So is the UN or are some of these treaties going to be revamped or revised or scrapped? Is there going to be an updating of that 50-year-old philosophy?
I don't know. That's a good question. I get your point. I understand your point, and I agree with it, that there was, in 1960s and 1970s, when most of these treaties were drafted and so forth, the only players that were out there were the countries, right? And there was really the United States and the Soviet Union that were the big players. And yeah, actually somebody at the University of Chicago had, and I haven't had a chance to look yet, he suggested that the impetus for the outer space treaties, that he wondered whether part of the foundation for those came out of the Antarctic treaties, which were, from my understanding, on a brief conversation, that came out of the need for researchers in different countries to work and research in the Antarctic and to use that space and so forth. I'm not familiar with it at all. That's a homework assignment that I have. So I don't know goes with that. It certainly was a different time. And going to your question, I agree that now, you know, the whole interest, the focus is on commercial development of space, or whether that's commercial by itself or commercial collaboration with the government. You know, the United States government definitely wants to collaborate, and they want that partnership, not only because they don't necessarily have the funds to do it themselves, but there's a lot of funds in commercial activity. So does that change? Would the treaties change? I don't know, but I do know that it seems that in research, in science, that you know, there's an ideal there that's lacking in other areas of our lives, like politics and so forth. And the fact that even though the Roscosmos director thought that we had sabotaged the Russian side of the ISS with that air leak, you know, there is international cooperation up there. There is international cooperation on scientists. The individual that referenced the Antarctic Treaty was interesting because it came from that international cooperation in science and research. So I don't want to lose that aspect of the treaties, and I think that we need to make sure, as much as I am in favor of commercial activity and development and want us to go to Mars and wherever we need to be, I think that there's got to be that collaboration, and there's got to be the determination of policy that protects the research from the commercial activity. And that's what plays out in Mars, the series in National Geographic. And, you know, the guy from the company, you know, the researcher, the woman that's leading the research team there is in charge, is talking to him about, you can't do that, you know, this is our research and so forth. And I think she mentions the Outer Space Treaty. He's like, who's going to enforce it? You know, we're a long way away from anybody that's going to do any enforcement. But I think your question, as well as a lot of the other questions, are really hits the nail on the head. And I think that that's why we need to be talking about these issues, and we need to determine the kind of environment that we want. It needs to be one that facilitates commercial development, and the only, apart from, you know, Elon Musk and Jeff Bezos perhaps having an interest in space and wanting to do something there, the commercial drive is profit. A company's got to see a commercial basis for doing anything. And if that is not there, or if the treaties or our statutes preclude that from happening or diminishing, then commercial interest is going to die off. And I think that's a balance. And that's what the Space Act of 2015 was designed to do, is to try to eliminate restrictions, or at least mitigate them. And in fact, a talk that I gave here previously that was focused a bit more on like ITAR regulations and EAR regulations, the Department of State and Department of Commerce just came out with a request for comment that concluded in April 22nd, I believe, where they were asking for comments from the from commercial aspects, from like, are there any aspects of ITAR, the technology that fits in ITAR? And for those that don't know, it's the International Traffic Arms Regulation, which governs export controls in the United States. And it's the highest kind of EAR falls below that, and that's the export administrative regulations, if I'm correct. So if any technology falls within ITAR, which is actually correlated with the United States munitions list, you cannot share technical information about that to anybody that's not a United States citizen. And you can't sell product to somebody that's not in the United States where that falls within ITAR. And so the question was, are there any aspects of space-related items on the United States munition list that have become so commonplace in usage that they should be excluded from that? Another comment was more to astrophysics, and that was like, I didn't know that the James Webb Telescope had to be specifically excluded from ITAR so they actually created an exemption directed solely to the James Webb Space Telescope. And the question was, look, we really shouldn't have to do that for every telescope that is looking outward rather than looking down. So is there a way that we can, are there some aspects of the optics or the mirror length and so forth that we can adopt that would enable that? I asked some colleagues, if not legal colleagues, but I asked some colleagues if they had any comments on that, and I really didn't get any, but I did read a response, and it was way over my pay grade as far as the technical aspects. But that's the kind of community that, like on those ITAR regulations, where astrophysicists or astronomers should be keying into that. And another thing that was interesting, in one of the responses to the request for comment, I forget the organization, but it was a collaboration of universities, research universities, and the comment was made that ITAR is so restrictive in the university context that many professors will dumb down their course material for fear of violating ITAR. And so those are the things that we need to be looking at, and we need to be aware of that. And going back to your question, not so much necessarily on the treaties, but going to the objective of the Space Act and other efforts to make it conducive for commercial exploration of space, we need to be aware of those opportunities to provide requests for comment or comments in response to those requests so that we can affect the policy change. Because that is the government asking us, hey, what are your ideas? How do we change the law here to make it better? And if we don't respond, then we only have our own selves to blame. Yes.
I've got to leave for a conference call, but what comment and question? One, I still think the best thing on Salvage is Andy Griffith's TV movie on Salvage 1. We talk about maritime law as the best analogy for salvage in space, but it seems to me one key difference is in maritime law, when you set your ship out, you expect it to come back. In space, we seem to have two kinds of things. We set up things that we ourselves label as expendable. If I've labeled what I'm sending out as expendable, what right do I have to consider it not abandoned?
Why do you think it would be abandoned just because it has an end of life?
Because I said it was expendable. I have no expectation whatsoever of getting it back, like I expected my ocean ship to come back. I'm sending it out never to return. Why wouldn't it be? How can it be more abandoned than that?
I think that your question goes to the very aspect that we need to perhaps implement what was the other principle you asked about earlier? The legal principle?
Superseding clause.
Yeah, so superseding clause, and arguably that if you send something out into space, maybe there is some kind of abandonment. What is interesting related to that, though it doesn't answer your question, is the change on aspects that anything that we are, this goes back to the mitigation of space debris, and that anything that we do send up needs to have some mechanism that it would burn up at end of life, so that it is eliminating that. And that kind of drives home the point that if you send something up and you know that it's going to deorbit and burn up, then...
Isn't that fair game for you to collect before it burns up?
I think you could make that argument. I think the Russian government might disagree with that perspective, but...
I'm wondering if one can make an argument that by boosting a satellite to a graveyard orbit, you are explicitly abandoning it.
Like Jeffrey said, I think that's a good argument that if you put it there, you're not expecting it to get it back.
So this might be more of an accounting question than a legal question. But at what point does a resource become a reserve that I can leverage on my balance sheet?
Can you repeat the question?
At what point does a natural resource become a reserve that I can leverage on my balance sheet as a company?
That's a good question. Does anybody have a possible answer to that?
The analogy would be oil companies that identify a reserve. Yeah.
Well, so I'll go back to what prompted my exploration of the ownership of minerals in an asteroid, going to your question. Because the question that was posed to me by my friend from college, that's an astrophysicist at the University of Michigan, he said, if I identify an asteroid that has a rare mineral that's extremely valuable, how can I claim ownership of that? Or is there a possibility to claim ownership of that? Can I do something if I identify it, can I say that that's mine? And the answer to that question goes through the law of salvage, abandonment. You get to the law of fines, because abandonment and salvage really don't apply to an asteroid. The law of fines does. But where I said earlier that possession is 9/10 of the law, you actually have to possess the mineral to actually claim ownership of it. So he was, it was a hypothetical, but he would not be able to claim ownership just by identifying it. And even though you know that there's a resource there that you're tapping into, you can't claim ownership of that until I would say, using that analogy, that you don't have ownership of any kind of reserve that's in a celestial object until you've acquired it and have it in your vessel or your possession.
To add on to it, I listened to a professor who's a law professor at the Air Force. I'm pretty sure she was probably at the symposium as well. But she was talking about how, for the moon at least, not necessarily asteroids, maybe a different mechanism, but that you can't own, in this line of thought that she was presenting, you couldn't own the land, but if you place something, you own that material or that structure. And so if you were to collect the water on the moon and you put it in your silo, then that would be the answer to the question of, well, now you have possession of it. It might not be going anywhere, but it is now a reserve that you have control over for your balance sheet.
Yeah, I mean, right. If you have the machinery to extract, you own the machinery, you don't own the land that you're on. And as you pull up the water or whatever resource and put it into your storage vehicle, then you own what's there. But what's interesting, and I think that my answer stands, but I will allow anyone to correct me. But what's interesting in both those questions is, let's say that I do put the mechanism to be, piping up water or whatever the mineral happens to be, but then just over on the other side of the crater, somebody else does and does a diagonal drill into the same reservoir. They're pulling it. Can I argue that they're pulling from my reserve or my reservoir? And the answer to that would be no, because until it's in my storage container, it's not mine. Yeah.
One thing that, I guess this is a point of conversation, and I wonder if you have a sense of this, is that there is some, in that example, there'd be some kind of conversation around safety zones of like, if someone's drilling from your reserve, if they're within a certain amount of space from you, whatever that defined area might be, it could be considered dangerous and therefore a violation and therefore like stealing from you more directly. I think part of that's coming from protecting like the moon lander that's on the, right now, like regulations around that. So I wonder, has that popped up into any of your conversations as far as your conferences go when you have dialogues with people?
I don't know about that specifically, but yeah, I mean, in the broader sense of being responsible and safety, the general principles have it. I don't know the specific aspect, but it's a good question. And I'm glad that you, even though that's what I was thinking of, I want to look actually at the law on oil and so forth, because that would be interesting parallel. But I'll take one more question, but I do have a 12-year-old waiting for me to have cake with him, so